This Honorable Court of Appeals is in session.
Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate both of you agreeing to participate in oral argument via Zoom. It's the best way we think we can keep things moving and accomplish what we need to accomplish. Having said that, I want to remind each of you that we are going to follow the same rules and protocol that we would as if we were all standing in the courtroom here today. I do not anticipate any technological problems, but if we encounter any, everybody just hang on, remain calm. We'll get it fixed and make sure that nobody is prejudiced by it if it occurs. Also want to be sure and introduce our panel for this afternoon. We have Judge Kenny Armstrong from Memphis, Judge Carmen McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we call the case?
No, Your Honor.
You may call the case, please.
Martina Smith et al. Versus Donna Jean Walker et al.
All right, Mr. Henson, we will hear from you.
Thank you, Your Honor, and good afternoon. May it please the court. My name is Sam Henson, and I represent the appellant, Martina Smith et al. At this time, I'd like to request 4 minutes for rebuttal.
Yes, sir. Thank you.
Judges, if I may start, I'd like to start by first off apologizing to the court. I allowed my original brief to leave my office without a single citation in it. And opposing counsel was correct in pointing that out in their response. So in my reply brief, I was certain to include all the facts again and cite to every aspect of the record that I could. And I hope that the court will accept that. I know it's not this court's job to scour the record to look at any of the proof that we submit, but I do want to apologize for that and hope that the reply brief will cure any issues that may exist there. Your Honors, the Circuit Court of Henderson County, or Madison County, excuse me, erred when it ruled that an as-is clause in a purchase and sale agreement between the parties essentially acted to absolve the defendant of any liability in this case. And the court erred for two reasons. Number one, an as-is clause, as this court is aware in the state of Tennessee, is only valid in the absence of any intentional or fraudulent misrepresentation. In other words, if there was intentional fraudulent misrepresentation that resulted in the parties entering into the purchase and sale agreement, as-is clauses are not valid. And number two, although the plaintiffs or the appellants in this case don't have necessarily any direct proof that the appellee intentionally misrepresented the condition of her home, we have supplied sufficient circumstantial evidence to at least allow a jury to take a look at that question. So as far as the first point goes, the court ruled that the as-is clause invalid or basically absolved Ms. Walker, the appellee, from any liability in this case. And it did so without really considering the nature of the proof that we had presented. We had alleged in our original complaint that Ms. Walker, the appellee, had intentionally or fraudulently misrepresented whether there was mold in her house. And the representations that she made that led my clients to believe that the house was mold-free was, number one, they walked through the house and she made no mention of any prior mold problems and made no mention of any existing mold problems. Number two, and I think most importantly, in the disclosure form that was required under state law, there's a section in the disclosure form that gives Ms. Walker the ability to check yes, no, or unknown as far as whether or not she knows of any material defects that were present in the home. Specifically, there's a section in the disclosure form that deals with environmental hazards. Now, it doesn't specifically say mold, but I think mold, most folks would agree mold is an environmental hazard. It's certainly a substance that might cause some sort of concern in that nature. And that's exactly what that section of the disclosure form, that's why it's in there. So my clients were led to believe that there was no mold issues in the house. They moved in and within just a few days of moving in, they started experiencing health problems. They had a mold remediation expert, Brent Horton, come out and take a look at the house. And he discovered, and as I pointed out in my brief, he issued a report detailing that virtually the entire house was contaminated with not just one type of mold, but with multiple strains of mold. In addition to that, after they discovered that there was mold in the house, they also discovered that there had been mold killing paint or primer that had been applied to certain floors in the house. And we even found the actual buckets of paint that were mold killing paint and primer. There were dehumidifiers that were present in the home that Ms. Walker said were there simply because of a minor humidity problem. In her deposition, Dr. Walker admitted that she had had mold issues in the past, but did not have a professional mold remediation expert take care of the problem. In fact, she testified in her deposition that she had a neighbor who was just a handyman to come over and try to remediate the mold problem. And then another piece of evidence we provided, which I think absolutely goes to show that Ms. Walker knew there was mold in this house. She testified in her deposition that she threw away family photos and personal items and furniture. And her reasoning was that where she was moving to was just a smaller place. Perhaps that's true, but the circuit court failed to consider the fact that all of those pieces of evidence, while circumstantial, admittedly, a jury very well could conclude by preponderance of the evidence that is evidence showing intentional or fraudulent misrepresentation. And
Okay. Mr. Henson, let me stop you here. Tell me how this evidence was presented on this motion for summary judgment.
I'm
yes,
sorry, go ahead.
No, go ahead.
As far as, for example, the mold killing paint and primer, we actually had pictures of that we supplied attached to my response in opposition and supplied to the court. Same with the dehumidifiers. I think we had pictures of that. And then the other ones.
Did you have affidavits?
I'm sorry?
Were affidavits presented?
There was not any affidavits regarding at least not regarding the mold killing paint or primer, but the remainder of the evidence we presented just came from deposition testimony. For example, Dr. Walker acknowledging that the molds that she had dealt with in the past and had a neighbor fix, that was deposition testimony. The fact that she threw away all of her personal items and pictures and furniture and stuff, that was deposition testimony. But then the mold remediation expert that we had come take a look at the house, he actually supplied a report detailing exactly what he found and how much he found, and that was supplied to the court as well.
Well, was there an affidavit attached to that?
Not from Mr. Horton, no, sir. Just his report was supplied to the court. So
can the court even consider that?
I think so, Judge, because I mean that's what a summary judgment. That's what it's essentially testing, is whether or not, number one, is there a material disagreement, and if so, is there any evidence that supports that? And what I argued to the court, the circuit court, is that all the evidence we've supplied, yes, admittedly, it's not direct proof of anything. That it's not direct proof of intentional misrepresentation, but what it is proof of, it's circumstantial proof of that. And that's why I think the court erred in that regard, because again, this is a civil case, and the plaintiff's burden in a civil case is just by preponderance of the evidence. In other words, just 51%. And I think the evidence that we supplied is more than sufficient to survive at least a summary judgment motion, because essentially there is a disagreement between the parties. The appellee states that the evidence we provided is not proof of intentional misrepresentation. We would submit that it is proof of that, circumstantial, and that a jury could very easily believe that.
Let's talk about the report. Did opposing counsel stipulate to the validity of the report or admissibility of the report?
Oh, no, sir. That certainly didn't. Not as far as the the summary judgment motion is concerned. But
How was that authenticated then in any way?
well, it was just submitted as consideration for this motion for summary. I mean, that's all we had gotten to is the motion for summary judgment. And that was just because part of their argument in the motion for summary judgment was that we didn't have proof of intentional misrepresentation. And even though our argument is, yes, we don't have direct proof, all of these other items of evidence taken together should be more than enough to at least let a jury consider this question.
Okay. Did the court consider the evidence you submitted? Or did the court say?
I don't think in Judge Atkins' ruling, the day we had the hearing, it didn't sound to me like he considered it very much. In fact, if I remember correctly, I think he ruled that this was a negotiated as-is contract, and as such, he granted the motion for summary judgment. And I felt he didn't take enough time to consider what evidence we had, circumstantial evidence we had of intentional misrepresentation, because I think, especially when we're just talking about preponderance of the evidence, I think a jury could easily look at this evidence that we've had, even in the deposition testimony, and conclude that this was intentional. And if so, then the as-is clause is not valid. But I think the circuit court jumped the gun a little bit by just automatically ruling that the as-is clause was valid because it was negotiated. And that's true. The parties reduced the purchase price by $50,000 as a result of this as-is clause. And I think that's all the court needed. When
Mr. Henson?
Yes, Your Honor.
Didn't the court also make a finding that there was no proof of any misrepresentations by the defendant?
I'm not so sure the court went that far. I think the court just said, well, yes, Your Honor. I mean, obviously the court, because it ruled the as-is clause was valid, felt that there was not enough proof to overcome that. But I think the court erred there. I mean, I think a jury, as I was arguing earlier, I think a jury could easily look at just the sheer amount of mold that was in the house as evidence of intentional misrepresentation, not to mention the mold paint killing primers and the dehumidifiers and all of that. And I see that I'm out of time. So Your Honor, if any other question, I'd be happy to answer it. Otherwise, I'll yield.
Just one question. You had the deposition testimony of the defendant.
Yes, sir.
Regarding the stuff she threw away. Other than that, there were no affidavits or other depositions that the court considered. Would that be accurate?
My client's depositions were taken as well, and I assume the court considered that as well.
But there were no affidavits introduced.
No, Your Honor.
Okay, thank you. Appreciate that. Mr. Soren, we will hear from you for the appellate, please.
Thank you, Your Honor. I'll only need 11 minutes, or if not that much. May it please the court, again, I'm Mark Soren for the defendant appellate, Dr. Donna Jean Walker. I'm going to go in the opposite order of Mr. Henson, and I'll address the merits first. First, I think Judge McGee was right on point. The court made two findings. First, that the as-is clause absolved the client from misrepresentations and other claims. And then second, that there was simply no proof in the record that my client intentionally made any intentional misrepresentation in connection with the real estate transaction. I think we agree on the law that an as-is clause absolves all the claims except for the fraud or the intentional misrepresentation.
Mr. Soren, is that true even if in the disclosure the seller misstates what they were aware of?
Well, that would be an intentional misrepresentation, wouldn't it? I mean, if they mistake what they're aware of, there's just, that's how I would answer that question.
Yeah, in other words, you can't just say, oh, it's as is, so I'm just not going to tell the truth on the disclosure.
No.
I know this stuff exists. I'm just going to say no to everything.
Right. The problem with this case is there's just no proof that my client knew. There's not even circumstantial proof that my client knew that there was mold in the house. If you look at the language of the disclosure form, it says what the plaintiff knew or what the seller knows at the time that they're filling out the report. The testimony during Dr. Walker's deposition was that it had been years and years before that she had mold. And the truth of the matter is, her testimony was that there was mold on a piece of furniture that she threw away. There was not. She went over and above and replaced a wall that was next to that piece of furniture, but the only mold testimony in the case is that it was on a piece of furniture. Judge Stafford was right on point. The mold killing primer photos, the photos of the humidifier, the report from the mold inspector, those were all just attachments to a motion or a memorandum. They weren't part of the record. And as your honors are well aware, Rule 56.04 requires a trial court to consider only the pleadings, depositions, answers to interrogatories, and admissions on file, together with any affidavits. None of that was presented to the trial court. There is nothing in the record before your honors that meets that level of proof. It's simply just attachments, unauthenticated, and many times illegible. I still have failed to find in the report from the mold inspector where it says the house is completely contaminated with mold. I found a citation a statement in there where there was 10 to 50 square feet of mold in a many thousand square foot home. I do also want to address Dr. Walker with regard to throwing away everything. She was moving out of a house that was many thousand square feet into what they call a tiny home. I filed her affidavit, her interrogatory answer explaining this. She moved from 3 or 4 or 5,000 square feet into a 500 square foot mini home. So where was she going to put that stuff? I mean, she was retiring and moving to North Carolina to retire. I don't think there's any circumstance that creates a circumstance that she knew there was mold because she threw stuff away. The trial court was correct in granting the summary judgment. I also want to explain that the disclosure form in the real estate contract specifically placed the burden on the buyer to determine if there's mold in the house. The environmental hazards, that section of the disclaimer form in the real estate contract specifically states that environmental hazards such as mold require advanced techniques by environmental specialists to evaluate, remediate, or repair. It's strongly recommended that you, the buyer, secure the services of knowledgeable professionals and inspectors in all areas of environmental concern. So the burden was on the plaintiffs, appellants, to determine if there was mold in the house, if they had any question about that. And another fact that's in the record is that the plaintiffs moved into this house many days before they closed on the house. So if the mold was so bad, how did they know? How did they not know? Excuse me. As to the state of the plaintiff's brief, the appellant's brief didn't contain a single citation of the record. Rule 27 of the Tennessee Rules of Appellate Procedure clearly states that briefs shall contain appropriate references to the record. Rule 6 of the Court of Appeals states that no complaint of an action by a trial court will be considered unless there are specific references to the record. Not one reference to the record in the plaintiff's brief. I quoted the City of Sumner versus Kelps case extensively in my brief. A frivolous appeal is one that is devoid of merit or one that has no reasonable chance of succeeding. Thus, an appeal in which a reviewing court's ability to address the issues raised is undermined by the appellant's failure to provide an adequate record is deemed frivolous because it has no reasonable chance of succeeding. Given that definition of a frivolous appeal, this appeal is frivolous, and the appellant is entitled to dismissal of the appeal and to remand for the determination of just damages pursuant to 27-1-122. There was one other thing I was going to say and I forgot it. Do y'all have any questions?
I see none.
Seeing none and cannot remember my last point, I will leave it to you all.
Thank you. Thank you. Ms. Tenson, you have 4 minutes, I believe.
Thank you, Your Honor. Just to address a few points opposing counsel made. One of the points opposing counsel made is that courts can consider in motions for summary judgment anything that was included in interrogatories or answers to discovery. Every bit of the evidence that I've already discussed was submitted multiple times in this case, not only through interrogatories and requests for production of documents, but also as attachments to our response in the motion. And the appellee keeps suggesting that we have not provided proof of intentional misrepresentation. And I don't want, we have not provided direct proof. We don't have admissions from Dr. Walker or witness statements or anything like that, because a lot of times in these cases, you're not, that's exactly what a cover up is. You're not going to have direct proof of it. You're going to have circumstantial proof of this. And one of the cases that I cited in my reply brief, which was a Davis, a 2010 Supreme Court case, Davis case, intentional misrepresentation can be proven by showing that the defendant acted recklessly. So when Dr. Walker on that disclosure form, when it said the portion where it says, talks about material substances and environmental hazards present in the home, she had the option of marking yes, no, or unknown. I would argue she should have marked unknown, but she didn't. She marked no. That is a direct representation to my clients that there was no mold or any environmental issues present in this house. And my clients were not there. I think it was 6 days they had lived in the house when they started realizing something was wrong. So to suggest that we have provided no proof is just, I'm respectfully going to disagree with opposing counsel on that, and would really ask the court to allow to essentially allow the jury to make this determination. This is whether this evidence that we have produced is sufficient to conclude beyond a preponderance of the evidence that this was intentional or not is a question for the jury, not a question for the judge to determine. And for those reasons, Your Honors, we would ask that this court remand this matter back to Judge Atkins' court so that it may continue on the merits. And then, unless you have any questions, that's all I have.
I see none. Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and attempt to render a decision at the earliest possible date. We again appreciate you participating via Zoom argument.
Thank you, Honors. Appreciate it.
Thank you.
Ms. Dempsey, thank you.
Ms. Angie, anything we need to take up before we recess to the call of the docket in the morning?
No, Your Honor.
You may recess court.
This honorable court stands adjourned.
Thank you.